Hello, everyone. My name is Grant Henry, here to talk to you about an issue called civil asset forfeiture. Now, if you don't know, civil asset forfeiture is the practice that allows police to seize your property if they suspect you of a crime, even if you're never actually convicted of that crime. Oddly enough, the legal proceeding is brought against the seized property and not against the individual. So for innocent people whose property has been seized through civil asset forfeiture, legally regaining such property is notoriously difficult and expensive. Supreme Court Justice Clarence Thomas said that this system, where police can seize property with limited judicial oversight and retain it for their own use, has led to egregious and well-chronicled abuses. And I personally believe that it also threatens Tennesseans' property and due process rights by frequently targeting the poor and other groups least able to defend these interests. Now, one way that we need your help here in the state of Tennessee deals with this piece of code that you're looking at on your screen right now. You can read it for yourself if you want to, break it down fully, but the basic parts you need to know are this. Any person asserting a claim to any property seized, basically meaning if they've taken your property and you want to be able to show up in court to get that property back, you're now one of these individuals that wants to assert that claim. Assert a written claim requesting a hearing, that's you. You have 30 days to do that. You have 30 days to assert this claim. Now, if the time limit was enough there, 30 days, you also have to be able to pay $350. One more time. Any person wanting to assert a claim must do so within 30 days and has to pay $350. Now, what does that mean? That basically means that you, a person who just had their property seized from them, must turn around immediately and pay $350 just to get your name on the docket. You have to pay $350 just to be able to show up in an administrative proceeding to try and prove the innocence of your property. You have to pay $350 to get the opportunity to get your stuff back, is basically what I'm saying. Moreover, you have to pay this money even if you were never actually convicted of a crime. And if that wasn't bad enough, clearly, Tennessee is one of only 3 states in the entire nation that requires this $350 surety bond. So what are we hoping to do about it? Well, this bill right here. House Bill 59, Senate Bill 260. Representative Grills is carrying this in the House. Senator Nicely is carrying this in the Senate. House Bill 59, Senate Bill 260. And it simply says this. Removes the requirement for a person to post a bond when filing a claim to seize property. That $350 surety bond we're talking about, it simply removes that requirement to pay that $350 bond. We think it's a fairly simple thing that's being asked for. When interviewed about this, Senator Nicely said the following. He said, when the state and law enforcement are taking more cash and property than criminals, you know it's time to do something about it. My bill addresses the bond that is required to have your day in court to get your property back. The bond requirement needs to be eliminated. That is what we're asking you to do right now. Help eliminate this bond requirement. You can do so by contacting the individuals on the Civil Justice Subcommittee. At the description of this video, regardless of where you're watching this, you will find the information for every member of the Civil Justice Subcommittee. Their phone numbers, office phone numbers, and their office emails. We're asking you to reach out to them, drop them a voicemail, call them personally, send them an email, and ask them to get rid of the surety bond and to vote to approve House Bill 59.